And the first case is ANTOURY versus State of Florida. Mr. Blanger, are you ready to proceed, sir? Do you wish to reserve any time for rebuttal?
I'll reserve 5 minutes if I could. I believe these are...
Hang on just a minute. Let me get this.
Do I have 15 minutes, or is it I have half of 15 minutes?
You get a total of 15 minutes, and you've reserved 5 of it, so you can talk 10, and then...
That'll be fine.
You may begin, sir.
Thank you. I appreciate y'all's time and attention. Mr. Justices, we're here on a criminal case, obviously, in which George ANTOURY was convicted of attempted sexual battery, if I'm not incorrect in this matter. And I believe the court granted a judgment of acquittal on the charge of false imprisonment in the case. It's an interesting case because there were 2 major witnesses for the state in this case: the alleged victim and her testimony, and the law enforcement officer who took the statement from my client. There was a woman who testified from Covenant House, but her testimony was very brief and more of a corroborative nature that she saw my client, or saw the victim in a fetal position and saw that she was upset and called law enforcement. There's no physical evidence of any sort in this case. The victim advised that she washed herself and cleaned herself up, and there would be nothing, and there was nothing there.
Let me just interrupt your argument a minute. We've read the briefs, and we're familiar with the facts in the case, but there's one issue that I would like to address that is troubling to me, and that is you've argued that there was error in excluding the evidence of ANTOURY's taped interview with the police, and their response is, well, even if it was error, it was harmless error. Could you comment on that?
Yes, sir. I don't think there's anything more important to a defendant who's on trial than for his lawyer to be able to adequately cross-examine the key pieces of evidence against him. In this case, Mr. George ANTOURY had 2 pieces of evidence against him. He had the victim's testimony, and he had the testimony of the law enforcement officer. Now, the state very cleverly sanitized the statements they were going to bring out from the law enforcement officer that would in some way intend guilt from the statement George ANTOURY made to the law enforcement officers. And yet that statement is a single statement. It was a transcribed statement, which became part of the focus of this case. And the law is very clear on this, in my opinion, based on the Guerrero case, which we well cite in our brief. And it's very clear that if the state chooses to bring out statements that George ANTOURY made in a conversation to law enforcement or to anyone else through that witness, the law enforcement officer, it is fair cross-examination for defense counsel to be permitted to cross-examine on the rest of that statement, and essentially to even admit that statement, if necessary, to put his original statements that law enforcement said he made in proper context. It's real critical in this case because we have the testimony of the victim unrefuted in any other way except by what law enforcement can or cannot say and the victim's background. And our concern in this case was Judge Conrad makes some really strange statements to me when I'm attempting to cross-examine from this transcript, which was provided in discovery. Law enforcement officer admitted in cross-examination, yes, this was an accurate transcript of Mr. George ANTOURY's statement. Essentially, Mr. George ANTOURY is denying anything but consensual sexual encounter with the victim, denying that he forced sex on her in any way, and basically said there was nothing non-consensual. When she asked me to stop, I stopped and drove her on to her location. And it became critical to cross-examine on it. What's really interesting, too, is the prosecution didn't object initially to my cross. The judge did. The judge injected that you know you can't cross from this statement without first admitting it into the evidence. He's wrong. He's absolutely just dead wrong on the law. In order to admit the statement, we must first examine and cross-examine on a statement for the officer to admit that those statements were in fact made by Mr. George ANTOURY. We weren't contesting that the statement was in violation of his Miranda rights. It wasn't one of those situations. In fact, we were saying the statement was freely and voluntarily given. The court says I shouldn't be permitted to do this because I'm trying to avoid putting George ANTOURY on the witness stand. We'd already said in an opening statement we were calling George ANTOURY to the witness stand. What we were trying to do was effectively place before the jury the proper context of what the state had already brought out through the officer and tried to sanitize. In other words, the state wanted what looked incriminating in his statement brought before the jury and was to rest their case at that point. But the law says that if you're going to bring out a portion of a man's statement in that circumstance, it's only fair, in the best light of everything, that the other portions of that statement that put it in proper light, be brought before the jury. And for some inexplicable reason, Judge Conrad stopped us from doing that. At one point, he said, well, you can introduce a statement in your side of the case.
Well, I think you're missing the point of Judge Boyce's question, which was the State argues that the error was harmless, I think, essentially because most of the information was delivered to the jury eventually in any event. So that's the question we're interested in.
Yeah, and let me just amplify on what Judge Monaco just said. When you read the statement over, it really doesn't help you that much anyway. I don't know. To me, I don't. That was my concern, and so that's why I wanted to address the issue of whether it's harmless or not.
But when a jury very much acts on first impressions. When they're heard a small portion of the statement, the way the prosecution brought it out, just in the verbal testimony of the law enforcement officer, one would only conclude that Mr. George ANTOURY was admitting guilt. And where he wasn't admitting guilt, he was being untruthful to the law enforcement officer, and thereby looking just as guilty. But when you put it in proper context, that really isn't what was being said. George ANTOURY was a man who had a wife, who had agreed to go and talk to law enforcement about this matter in complete detail. I believe this conversation was over an hour. The harmful error is that if you're going to keep a jury in a neutral position to be a fair decider, that's why we require cross. That's why cross-examination is one of our essential rights that a defendant has before the State's case is over. Sure, we can always bring in other evidence later. I put up George ANTOURY on the witness stand to say what he said and what he meant. But he's the man on trial. And essentially, we have a man from Morocco of Arab descent after 9/11 who's on trial for raping a white woman, essentially. We have a woman's testimony. And the reason it's harmful error in this case is there are only two pieces of evidence. Her testimony and what appeared to be his confession to the law enforcement officer, which was in no way a confession. Because what he said is, yes, we did attempt to have sex. Yes, she asked me to stop. Yes, I stopped. There are other things in that statement that were pertinent for cross-examination. The young lady had lied to law enforcement. She had given her name as Miss Santiago, when in fact that wasn't her real name. She had also said that she had run to a bus stop and gotten his tag number, when in fact my client advised that he dropped her off somewhere in the vicinity of Orange and Colonial, which is 3 miles further west, a location he could not possibly have guessed at unless he took her there, which was within 1 block of where she was staying at Covenant House. Her testimony was fraught with all kinds of untruthful information, but the only way to effectively bring it out was to show that my client told law enforcement before he had any idea what she had said to law enforcement about what had occurred. And so being able to cross-examine on that statement and to show that statement during the State's case in chief was critical. Because once the State's done with their case, the jury's mind might very well be set. We might never overcome it. And for the court to inject itself and say, I know what you're trying to do. You're trying to avoid putting your client on the witness stand. You're trying to avoid putting the evidence statement in so you don't lose opening and closing. I don't even think those are proper arguments for the court. I don't even know why a court would be thinking in that direction. It seems highly inappropriate, but the harmfulness was that there are only two pieces of evidence in this case. Therefore, it's critical that we have a fair cross-examination of a law enforcement officer who appeared reluctant during cross-examination to admit things until we forced it upon him from the statement itself. Now, maybe it's because he didn't read the statement completely before he testified, or he focused only on which the prosecution wished to bring out. But that's not a fair trial. That's not a fair way for a case to be handled, and that certainly doesn't allow for this to be called a harmless error situation. On the other point, I think it's just as critical that we weren't permitted to go into the background of the victim. Now, I understand.
You would admit, though, that that's a discretionary call on the part of the trial judge?
Not necessarily, and here's why. It's discretionary within the limits of what allows for fair cross-examination of a victim's background that can bear on her credibility. The Rape Shield statute clearly was meant to protect the privacy of a victim from having a public castigation on issues that don't really lead to anything in the case, other than the fact that she might have consensual sex in the past. Those aren't relevant. We fully admit that. What we have here, though, is a victim who was sexually assaulted, not consensual sex, by her brother for years, who was never brought to trial or justice on the situation, that appeared to have been a great harm to her over the years, and a second event where a trial occurred in Osceola County where she testified against a man when she was underage who sexually assaulted her. She also advised that she came from a background where her family was quite alienated from her. She was living at Covenant House, and she had cut herself on her stomach many times, and she said it was self-inflicted, and that she had also pushed staples in her stomach to such an extent it required surgery. And what I'm suggesting to you is, isn't it relevant that a jury know the degree of mental hardness that this woman is having to deal with her mental background? Doesn't this affect her believability in a case where there's no physical evidence, where she's on a park or she's on a bus bench, and she freely admits to getting into a vehicle with a man she doesn't know?
It's a difficult line to really discern sometimes when you get into testimony like that. You've got 5 minutes left.
Let me, I have a question first, and it's bothering me, the fact that you were denied cross-examination on the statement. But I guess the question was, why isn't it harmless? Because the statement, or most of it, came in later anyway. Do you agree with that? And if that's true, how did the rest of the statement come in anyway?
I agree that portions of it came in anyway, but the officer was...
When did they come in anyway?
It came in through the testimony of George ANTOURY, who testified. But he's different than a law enforcement officer who's considered the neutral investigator. But I suggest in this case, by the way the state chose to use him as a witness, he wasn't simply the neutral investigator. The statement...
Did you get in everything that you wanted to get in from the statement through Mr. ANTOURY?
Not in such a fashion that I felt that this was a fair trial for Mr. George ANTOURY, because the jury was allowed to keep in mind over evenings and things of that sort what he supposedly had told law enforcement without a fair cross-examination. Now, I wasn't even going to argue today my third argument with regard to Judge Conrad. You all can look at that, take a look at it, and make what you will of his comment. Judge Conrad's known to be an outspoken jurist anyways. I've known him for many, 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 many years. He's a very bright judge, and I think the court can put that in proper
We don't go into the intelligence or the brightness of the trial judge. We simply look at the record and see whether there's a mistake. So
I think there are clear mistakes. And here's what I was trying to get to about the mistakes. We have an overflow division in Orange County that hears cases when judges' calendars are crowded, and it goes on a rotating basis. Certain judges, certain weeks, have Judge Conrad. He has that overflow. I'm convinced that part of the errors occurred in this case because the overflow judge is put in a tough situation on certain cases, ones that have some complicated issues, that have some very tight issues, where they haven't had the case for months to look at, haven't had a chance to talk to the lawyer in previous motions, things of that sort. And Judge Conrad gets this case on a Monday morning, like he does. I'm not sure every single case that a court wants to rid itself of and get handled by Judge Conrad necessarily should. And I think errors were made because I don't think he did fully understand what the situation was, as much as we tried to show him. Like we gave him the deposition of the victim so he could have every word she said. And that was our in-camera hearing, rather than bringing the victim into the judge's chambers and having her go back through it again. State not stipulated he could use that. But those are our arguments. Thank you.
May it please the Court, my name is Rebecca McGuigan, and I represent the state in this matter. As Judge Boyce pointed out on point one, it's an abuse of discretion standard. The trial court exercises discretion in making its ruling, and I think that that was a proper ruling in this case.
What about the denial of his right to bring out the other portions of the statement when it appears that you carefully crafted? I don't know whether you were the prosecutor, but probably not. But the prosecutor that tried this case carefully crafted these questions to elicit yes or no answers, and I thought that they were quite damaging. And then he's denied the opportunity to bring out the rest of the statement and put it in proper context, and that bothers me quite a bit.
The statements that he testified to are things that defense counsel had already conceded on opening, that he picked her up. She testified he picked her up. These are all things they're in agreement with. The only areas that they become into the disagreement is with the ejaculation and his concern about arrest. They also explain that he told the officer at the time that this was all consensual. The statement, like Judge Boyce said, I believe it was said, is not that helpful to him, and if you look at the last 2 pages, that is where he concedes that he ejaculated, and he's uncertain as to whether or not they're going to find sperm in his vehicle. So it's not that helpful, and also He was able to also,
No, but do you admit that he should have been allowed the opportunity to, to bring out in cross-examination some of the other portions of the statement, to put, the answers to these carefully crafted questions in the proper context, rather than him having to wait until he puts Mr. Antonori on the stand to do it?
I think it's not that, I don't.
Do you agree that it was an error for the trial court to deny him the right to cross-examine on those points?
Yes, but I think it's a harmless error.
I think it's harmless because he was able to bring most of it out by putting Mr. Antonori on the stand and explaining it.
Not just by Mr. Antonori on the stand, he also was able to cross-examine the detective on certain points, and he was able
On
to
certain points, but he
yes.
was limited. I mean, his cross-examination was pretty limited, wasn't it?
It was limited, but it was limited in the way he was asking the questions.
So these carefully crafted questions, it seems to me, left a big impact on the jury. He's denied his opportunity to fully cross-examine, and then he's got to wait till later on in the trial while this impression is left with the jury to properly cross-examine. And your only argument is, well, and that's harmless because the jury eventually heard it all anyway.
Well, I wouldn't say because it eventually heard it all, but he was able to bring out the statement that he didn't rape her and he didn't force her, in quotes, to the officer. If he wanted to get the entire statement in at the time for cross-examination, he should have admitted the audio tape. He could have done that. The trial judge indicated he would have let him do that.
So were you questioning the witness from the audio tape?
No, but that's...
Or you were questioning the witness from a transcript?
Recollection.
Right. And so why? And so you're saying then that, I mean, even though he's denied the right to cross-examine from the document that you're asking questions from, he has a right to cross-examine based on introduction of another tape, even though it's not his case. He's not at that point allowed to introduce evidence at that point. I mean, does that make any sense?
Well, under the rule of completeness, he was able to introduce that at that point.
Did the trial judge say? I mean, you can bring out
You can introduce the statement if you want. You cannot continue in the manner that you were doing.
Right. And you think
language from the transcript.
I think that's a proper way for him to conduct his cross-examination, to deprive him of the cross-examination from the document that your questions come from, that he can cross-examine the witness from something else.
He wasn't deprived. He wasn't saying he can't question him from the document. He said you can use that document to refresh his recollection. His objection to the defense counsel's procedure of just reading the defendant's statements in, sometimes not even asking a question with it, was the objection. And also when defense counsel started picking up the document and waving it in the air around in front of the jury. These are the things that the judge was angry with, and these are the reasons why his cross-examination ended up being limited. He could have asked more questions. He chose not to. So it is harmless. The defendant testified in this case. He was able to bring out all the things that he wanted to. The statement's not that particularly helpful. It shows him being evasive to the officer. And
Ms. McGuigan, what's the definition of harmless error?
Error is harmless when it doesn't go down into the jury's verdict, and I cannot believe I just...
We have to find that it's harmless beyond a reasonable doubt, right?
Right.
It's sort of an amorphous standard in any event. What is it about this procedure that you believe would enable us to conclude that the error did not affect the verdict in any way?
Because he was still able to get all the information in that he wanted to.
When?
During the defendant's direct examination and during some of the...
So he has to. So what you're telling me is that he has to wait for the prosecutor to finish the case in chief, go through all the appropriate motions, and then, well, maybe he doesn't want to put his client on the stand, but then he's forced to put his client on the stand to get out the remaining portions of the statement that he was prohibited from doing on cross-examination. So maybe he was going to put the client on the stand anyway. Who knows? But certainly you could at least make the analysis that put him in a situation where maybe he had to. And I mean, that bothers me quite a bit. I mean, I was surprised that the trial court would limit his cross-examination on that point. But we'll take a look at your harmless error argument and see.
We would ask that you affirm if you have no further questions.
Thank you, Counselor. Finally, you wish to respond to them? We'll give you a couple minutes. All right, thank you.
I delineated real effectively in my initial brief, and it lays out what Judge...
Wait, before you sit down, and I know you're anxious to get away. Something that Ms. McGuigan said was something that it hadn't occurred to me before. What, in your cross-examination, how were you using the transcript? Were you simply reading pieces of it to the jury, or were you asking questions based on the transcript?
I asked the officer if this was an accurate transcript of the statement that my client made to him. And was that the only statements?
Why didn't you just put the videotape in?
Because it wasn't my case. It was the state's case in chief.
Well, but when it got to your case, why didn't you put it in?
When I got to my case, I put my client on. The court had at one point, if I remember correctly, if you look at that portion of the transcript, if I'm not correct, the court wouldn't permit me to put the statement in. So I
would or would not?
ANTOURY on the witness stand, which essentially I had intended to do anyways with this lack of record. Now, the situation is this. What the court was permitting me, when that says waving around, I'm waving around like I'm carrying this now. It wasn't being waved around. I don't do that. And it was the court who brought up that it was being waved around. It isn't a matter of being waved around. There wasn't any issue that this was an accurate transcript. We all had it. What we were trying to do was when an officer was saying that my client said something that was yes or no, I said, but officer, in context, didn't you say this to him and didn't he say this to you? And my intention was to show him the transcript. What the court kept doing was threatening if I didn't stop doing it, it was going to be bad for me. And that I needed to stop because he was objecting to me doing that because the transcript was not in evidence. In truth, if you're going to admit a statement, even in my case in chief, or in my side of the case, you must first have the witness hear those portions of the statement and either say, yes, that was what was said and I remember it, or that was not what was said. And it is in cross-examining him and bringing out what was relevant that my client essentially was not admitting to having forced sex with this woman. In fact, he said it was consensual. Now, it's a rather lengthy statement. It's over an hour in length. I don't think there's any way to call this harmless error in the circumstances of this case. It could be in some cases. Not this case. Not in this case, rests solely on the believability of Ms. Santiago, who is actually Ms. Rosa Williams, and her checkered past, and the law enforcement officer's very sanitized version through the prosecution of what my client said. Now, if that's a fair trial, we don't have fair trials.
Thank you, Counsel.
Thank you.